already. Yes, beautiful. Yes. Now, that is, we will do. We are using the baby to have a money. She will be the one to reply. When time is up, atasema, you have obviously discretionary minutes. However, remember, this is a knockout round, and obviously in your memorial, in your score sheets, you have time management. So get them also on time management. Baby, this time, when they ask a question, just give them discretionary minutes so that these guys can. And now, for us, the microphone is very sensitive. So ukiekelea chini inakuoga. Ukiekelea tu just itakuoga. Itaharibu kila kitu. So handle the microphone here. And if you're not using it, press once to make it use. Press this once. Once to utaona hiyo mute properly. Nasema it's not working. So I shall understand. Yes. Man, press once to use. Press once again to use. And iweke tu vizuri chini pole pole. Same hivi. Chini. I'm waiting for you so that you go from the one side. Oh, wait, let me see. I have stolen someone's charger. I stole someone's charger. No, that's not fine. Yes, anyways, I stole someone's charger. Yes. So, I wish you guys all the best. You guys look great, you look beautiful. Very beautiful. I love your students. Measure. Okay. The main. Read 2 minutes. Please run.
I don't know if I can get about this.
If you want to, please run. So that come up with anything else. Yes, you just go straight. Because we still have to announce the results today.
Today, like
Yes.
after this round.
After the last round. Please run. Yes, and Leticia, welcome to the live. Welcome. Let's make sure you, once I share the link, make sure you tell people to subscribe. Yes, and you go to the chat and to say which team is your favorite. Yes. Meaning my favorite team is the team that will win.
It's actually very easy. If you just state the action provision you're stating and you are very good with your words.
Yes. Otherwise, they can calculate in movie for a bit. But yeah. Yesterday niliona ile swali niliulizwa na Duncan. Ile swali fulani niliulizwa na Duncan, alafu Amani kama compound ile moja. Wow, I was so sad when I felt so bad. I'm sorry. I wanted to clip that part, alafu I share it. Well, she was asked a question. Atamaliza, anauliza na Amani. So she starts with Amani, then you go to Duncan's swali. Duncan is not satisfied. Wow, being about his heart. Yeah, I will be there. I will chat. I will find a way.
That is not even funny.
Yes. Oh, I love food. Team good. Sorry, Ashken. These are the previous memorial scores. I want you to give them to you. These are the ones. See like how you react. You think you can improve. Yes. Oh, no, this is the look. First and second counsel, first and second counsel. So each judge gets two. Now, we are then the judge and the second judge it's Dr. who drafted this, not me. Yes, have you seen your moral course? Though, please take note that there is somewhere it says Inter-American court system. I forgot to edit that. That was my fault, but please see where you can meet now. Yes, this one. Welcome. Please come before we welcome the judges. You can come in. Everyone can come. Nicholas, we are about to start. The baby is about to motion the mother. So what's yes.
All rise. The matter in court is of the Republic of Malindi in the Environmental and Land Court at Nairobi, petition number 8 of 2024, between Kasili Community Organization and 2 others versus the Attorney General and 2 others.
So good afternoon, everyone. My name is Rashida Duncan. I will be presiding this round. I'll let my co-judges introduce themselves from right.
Good afternoon. My name is Alina Chemtai. I'll be co-judging this session. Good luck.
Good afternoon. I am Amani Andika and I'll be co-judge for this session and I look forward.
Good afternoon. My name is Shaman Brown. I'll be a judge in this session. Thank you.
So just some ground rules. We will be strict on time management this round, and it's a knockout, so only one team will be proceeding out of this round. You already know the petitioners and the respondent, so I'm expecting to have the petitioner, the first phase for the petitioner in 2 minutes. You have 2 minutes to prepare. Meanwhile, we can have the team calls. Let us have the team calls to begin with this team. The other team. So which one is the petitioner? Team that. So first counsel, ensure you introduce your counsel, fellow counsel, and tell us the amount of time each council will be taking so that the bailiff can pause the time when we are asking questions. And we will give 2 extra minutes for rebuttal for the petitioners. So that is, unless there is any question from the council, we can begin in a minute when the council for the petitioner is ready. You can take the floor.
Greetings, honorable members of the bench. May it please the court. My name is Mwangi Elizabeth Wangeshi, lead counsel appearing on behalf of the petitioners. With me is my co-counsel, Sylvester Daniel. We will use 20 minutes of this honorable court's time as follows. Lead counsel will use 10 minutes on issues A and B. We will use 5 minutes to discuss issue A, where it is our averment that this honorable court has the jurisdiction to listen to this case, that the petitioners have local standing to appear before this honorable court, and that this case is therefore admissible before this honorable court. I will spend 5 minutes to discuss issues B, where it is our averment that Talmud Limited should be held liable to its contribution to greenhouse gas emissions and environmental disasters, as well as the negative health impacts. My co-counsel will use 10 minutes, 5 minutes on issue C, where we aver that the Republic of Malindi bears responsibility under international law for transboundary environmental harm to Samira. He will spend 5 minutes on issue D, where it is our averment that the constitutional right to public participation was violated. He will then conclude by stating our prayers. We will reserve 2 minutes for rebuttal. Unless the court directs otherwise, I wish to proceed.
Proceed, counsel.
Honorable members of the bench, on the issues of jurisdiction, local standing, and admissibility, the petitioner asserts that this honorable court has jurisdiction to listen to the matters, that the petitioners have local standing to appear before this honorable court, and that this case is admissible before this honorable court. On the issue of jurisdiction, Section 13(2) of the Environment and Land Court Act bestows upon this honorable court original and appellate jurisdiction in accordance with Article 162(2)(b) of the Constitution to hear cases involving alleged violations of environmental and land rights. The Constitution of Malindi upholds environmental protection as a fundamental right, and the issues raised touch on the obligations of the states and private corporations to mitigate environmental impacts and protect community welfare.
Council,
Yes.
before you proceed, we have that issue on transboundary issue, the issue C. How does this honorable court have jurisdiction on that matter? When does this honorable court derive its jurisdiction on that issue C?
Much obliged, honorable member of the bench. This court has jurisdiction to interpret the issues of transboundary harm. However, it lacks jurisdiction to give orders, as this is an international law matter that is best handled in international forums.
So you do consider this honorable court should not listen to that issue?
It has jurisdiction to only interpret the issues, but it cannot give orders concerning the same issue.
Council, what will be of benefit to the petitioners if we can only interpret that matter and not give orders as to the release of the remedy?
Duly noted, honorable member of the bench. Kindly repeat your question.
My question is, what will be of benefit to the petitioners if we can only interpret that matter and not order or give order in terms of relief or remedies to the situation?
duly noted. The matter above is as a result of breach of environmental rights, which this court has jurisdiction to handle. Therefore, this court can only adjudicate on matters of interpretation. It is our submission that the parties have locus standi to appear before this court. In Black's Law Dictionary, locus standi is described as the right to bring an action or to be heard in a particular forum. In the case of Alfred Jau and others versus the City Council of Nairobi, the Court of Appeal held that the term locus standi means the right to appear or to be heard in a particular proceeding. To say that a party lacks locus standi means that they have no right to be heard in a particular forum. The petitioners have standing to bring this petition as representatives of the affected communities. Malini's constitution broadly recognizes the right of individuals and organizations to initiate public interest litigation pursuant to Article 22 and Article 258 of the Constitution of Malini. A person must have sufficiency of interest to sustain his standing to sue in a court of law. This was the holding in the case of Bibi Narayana Reddy versus the state of Karnataka Air. Environmental organizations and community groups such as Kasiri Community Organization can therefore litigate on behalf of the broader community, arguing that the government's Internal Moot actions have infringed upon the community's constitutional rights to safe and healthy environment, which is protected under Article 42 of the Malini Constitution. The matters herein are within this court's jurisdiction, hence are consequently admissible. The petitioners assert that this court has jurisdiction to listen to these matters, that the petitioners have locus standi, and that this case is admissible before this honorable court.
Also, on admissibility, does it mean that all matters that the court has jurisdiction are admissible? Is it that straightforward?
Duly noted, honorable member for this. The test for admissibility is done by two ways. The first one is existence of a legal dispute, and in this case, we can clearly see that there's an existence of a legal dispute where environmental and land rights have been violated by Talmud Limited and the states. Also, another aspect is exhaustion of local remedies. According to paragraph 20 of the fact sheet, as soon as NEMA announced issuance of a license to Talmud, community representatives approached NEMA, questioning the process of public participation and the project's potential risks. NEMA declined to respond and stated that all procedural requirements had been followed, when in fact the SCR process was flawed. In paragraph 21, community members held on and off demonstrations voicing their concerns regarding the sustainability of the project, noting that it will have damaging effects on the communities. Despite this dramatic showdown, the mining project took off. Further, in paragraph 24, environmental NGOs within Malindi, such as the Kiweni Conservation Group, issued warnings that the cement factory operations were contributing to greenhouse gas emissions, thereby worsening the climate change within the region and increasing the region's vulnerability to extreme weather events. Despite these numerous complaints, the state and Talmud did nothing to address these complaints, forcing the petitioners to seek redress in this honorable cause.
But counsel, there are two tribunals. In paragraph 14, we have the independent accountability mechanism, and in section 129 of MCA, we have the tribunal. Yes, we do not dispute that the community representatives went to labor, but instead they should have gone to the tribunal, not to labor, as the authority. they did not seek redress from the tribunal, which I believe could have jurisdiction on issue B, on the MCA, or rather the environment social impact assessment process.
Much obliged, honorable member of the bench. The petitioners approached MCA, right? And Section 125 of the Environmental Management and Coordination Act establishes the National Environmental Tribunal. Therefore, it was the MCA's duty to refer this matter to the National Tribunal, and it failed to do so.
Do you work with referrals? Does the tribunal work with referrals, or anyone in the district should go to the tribunal? From a reading of section 129.
Complaints were lodged to MCA, and they ought to have been addressed and referred to the tribunal.
Section 129 reads that any person who is aggrieved by grant of licenses, imposition of any condition, revocation or suspension, so any person is supposed to appeal to the tribunal, not never to the tribunal. So, is it in order we hold that on issue D did not exist locally?
NEMA, as a corporation, failed to educate the public on the appropriate measures they could take in case they were aggrieved. They had a faulty system of carrying out public education. With the permission of this court, I would like to proceed to issue B, where it is our affirmation that Nazarene Limited should be held liable for its contribution to greenhouse gas emissions and environmental disasters, particularly with regard to floods, landslides, and health impacts on the community. Nazarene Limited should be held liable under multiple doctrines, and we will use two lines of argument to support our claims. Our first line of argument is that Nazarene Limited should be held liable because of a clear breach of obligations under the SCR and the duty of care owed to the people of Kasiri community. The duty of care is a fundamental concept of tort law that requires Nazarene Limited to take reasonable precaution to prevent foreseeable harm to the people and to the environment. Paragraph 16 of the fact sheet states that Professor Bakari's assessment explicitly noted that the geological conditions in Mirenga Valley were prone to instability, potentially leading to ecosystem collapse, landslides, and flooding. Despite these warnings, Nazarene Limited proceeded without implementing the necessary risk mitigation measures that a reasonable corporation would have undertaken. Nazarene Limited disregard for potential risk suggests negligence as it fails to address critical issues identified in the SCR report. The Environment Management and Coordination Act emphasizes the duty of care in Section 3. It requires all industrial projects to undertake measures that mitigate environmental harm, particularly in projects like mining that carry substantial risk.
Awesome. I have a question. Can you get a direct link between Talmud's limited action for the contribution to greenhouse gas emissions and the effects of climate change that are being felt by the Republic of Mali? Like a direct link, because we see, even maybe, we see aspects of, I think in paragraph 6, we see that the leading source of greenhouse gas emission is the agricultural sector. And I think it's Article 69 of the Constitution also provides that it is in every individual's duty, like every person, to take care of the environment. Can you give us a direct link between the actions and the climate change.
Deliberate honorable member of the bench. According to paragraph 5, Malindi contributes less than 0.1% of the greenhouse gas emissions. However, the country has witnessed increased heat and recurrent droughts that have contributed to severe crop and livestock losses, thus leading to famine, displacement, and threats to human health and well-being. In paragraph 24, Kiseweni Conservation Group issued warnings that the cement factory operations were contributing to greenhouse gas emissions, thereby worsening climate change within the region and increasing the region's vulnerability to extreme weather events. In the case of Agenda Foundation versus Netherlands, where the court held that any greenhouse gas emissions, regardless of how minor, contributes to harmful climate change. Similarly, Talmud should be held liable for its contribution to greenhouse gas emissions and environmental disasters. I would like to request this court for two discretionary minutes to sum up my argument.
Council on
Duly noted. Talmud Limited is responsible for polluting local water resources with lime deposits, causing illness in children and death of livestock, according to paragraph 23 of the fact sheet. This pollution breaches environmental standards and violates the public trust doctrine, which mandates that.
Council, I want you to use your discretionary minute to answer this question in that issue. When you say that the government's activities concerning limestone is what contributed to the pollution of water, are you clearly certain that this is the case, considering the fact that there were already existing vast limestone deposits before the government's activities also took place?
In paragraph 23 of the fact sheet, I will read as it states. As the Kasiri Cement project was making wide use and receiving global and national applause, a section of Benega Valley residents were complaining that their once colorless water was starting to look milky and with rough debris in the natural flowing river. It was reported that 6 children between 10 and 15 years had received medical treatment for consuming the water. Additionally, cattle drinking water from the river were dying due to limestone and acidic burns in the ruminant digestive system. Tarbul Limited is responsible for this limestone deposits in the river, causing harm to people and to cattle as well. The pollution breaches environmental standards and violates the public trust doctrine, which mandates that certain standards should be upheld. In light of our submissions, the plaintiffs pray that this honorable court finds Talmud Limited liable for greenhouse gas emissions and environmental disasters. I will seek the floor to co-counsel.
Greetings, honorable members of the bench. May it please this honorable court, as earlier introduced by the lead counsel, my name is Sylvester Daniel, appearing on behalf of the petitioner as the second counsel. We will use the 10 minutes allocated to us by this honorable court to discuss on issue C and on issue D. On issue C, it is our government that the Republic of Malindi should be held liable for transboundary harm caused to the state of Samira. On issue D, it is our government that the environmental social impact assessment was duly flawed and violated the constitutional right to public participation. My lord, my lady, on issue C, I will submit my argument on two links. First, on the transboundary responsibility principle, and second, on the no harm principle. My lord, my lady, on the first link of my argument, that is on the transboundary responsibility, I will rely on the Rio Declaration of 1992, Principle 2, which states that states shall prevent transboundary damage, bearing in mind that they have sovereign authority to exploit their own resources. My lord, my lady.
Council, before you proceed, could you kindly answer this question? Was the government of Malindi in control of the activities carried out by the company Talmud Limited?
Much obliged, my lord. It is the petitioner's assertion that from the fact that the government contracted Talmud Limited to conduct the mining activities, therefore it brings on the principle of vicarious liability to the government. My lord, my lady, according to the 1996 legal advisory opinion on the legality of threat or rather use of nuclear weapons, the International Court of Justice recognized the general obligation of states to ensure that activities within their jurisdiction or rather within their control does not affect the environment of other states. My lord, if you can move with us to paragraph 26, it is very evident. It is very evident that that the floods contaminated water sources in the state of Samira, and the contamination came from River Mirenga, which was in the Republic of Malindi.
Council. My question is on paragraph 25. My question is on paragraph 25. We are seeing that in April 2024, the Republic of Malindi is experiencing unprecedented heavy rainfall, one of the rarest daily flooding which the country had never experienced in decades. Are you submitting that we should crucify the respondents on something that they do not have control on?
Very much obliged, my lord. It is the petitioner's submission that.
Council, as you respond to that, please keep in mind paragraph 4 of the same that states that the primary cause, that Malindi recently had to deal with erratic climate change patterns that have often resulted in a reduction in agricultural profits. The primary cause of this is the incapacity to accurately monitor and forecast weather conditions appropriate for agriculture in the region.
Very much obliged, my ladyship. On paragraph 16 of the compromise, the risk associated with the commencement of the project were well shown in the environmental social impact report that showed that the area was a soft ground. Therefore, by the action of the government going ahead and setting up the project, showed that they disregard to the neighboring communities because already the risk were already stated. So by doing that, they exacerbated the risk of having these risks come to true. And they did not take any mitigation to control these risks that were
Council, I don't have any issue with the ESIA report. Let me now lead you to questions. One, we see that the report only provides on the aspect of the soft grounds, right? Yeah. Does the report provide on the possibility of an unprecedented heavy rainfall? Was the unprecedented heavy rainfall something that was foreseeable for the Republic of Mali?
Much obliged, my lord. The activities that were taking place in the Kasiri Cement project increased or rather fueled, catalyzed the risk making this risk happen. And also, before these unprecedented floods came, there was a caution by environmental and non-government organization, as in paragraph 24 of the compromise. Therefore, it is very evident that the activities that were taking place in the Kasiri Cement project were increasing the rates or were increasing the chances of having these floods come. Therefore, it was their duty to ensure that the activities in the Kasiri Cement did not increase the risk of the risk happening. On the second limb of my argument, I will use the no harm principle. I rely on the maxim which states that sic uteretur atelam legas, which means that you can use your property as long as it does not cause injury to others. My lord, relying on the case of Trust Melter case between USA and Canada, the tribunal held Canada responsible for transboundary harm for causing damage in USA. Therefore, the Republic of Malindi had a duty to make sure that activities in their country did not cause any damage to other states, which is very evident that the polluted water that was caused by the activities in Kasiri Cement polluted the water sources in the state of Samira. If therefore this bench seeks no other clarification, I'd like to move to the next issue. On issue D, it is affirmed that the environmental social.
Before we proceed to the second issue, I want to know what you want this to do to Internal Limited, considering that paragraph 22 provides that within 2 years, the project brought immense economic benefits to the region, which included employment, investment opportunity for the community. We even see that Kasiri Cement was able to remove and store, that's carbon capture and sequestration, of 10,000 tons of carbon force, which means that they are even dealing with their own carbon emissions. And we also see that they also ensure that we have other socio-economic rights like the building of Kasiri Cement primary and secondary school, education bursary, and even cement water springs. What should the court do to these projects, considering that it's of immense economic benefit to the region?
Very much obliged, my lord. And it is our submission that this court should find that the project should find the Republic of Malindi liable, because in as much as the project went well for the first 2 years, for damage to happen there have to be accumulation. So the accumulation, and also as stated in paragraph 26, also the complaints from the people showed that after 2 years, this accumulation was getting worse. And therefore, it was due to this accumulation that they experienced the huge flooding. Therefore, it is their duty to make sure that the activities that they were conducting, they should have provided mitigation measures to make sure that the activities did not affect the state of something. On our second issue, on our last issue and issue D, it is our comment that the environmental social impact assessment was duly flawed and violated the constitutional right to public participation. My lord, my lady, before I continue, I want to classify this project according to the Environmental Management Coordination Act of 1999 as a high-risk project. Therefore, it being a high-risk project, it required an environmental social impact assessment, because mining under the second schedule, subsection 2, section 2, subsection 6, subsection G, it categorizes mining as a high-risk project. Therefore, for high-risk project, it is required for the state to conduct an environmental social impact assessment, which should be well conducted. My Lord, therefore, if it will be the respondent's assertion that the process was well conducted, I would like you to refer them to the MCA. My Lord, supporting that, I will use the case of Patina and others versus the National Management Authority in the environmental land case in Nairobi, where the court held that for projects which are categorized as high-risk projects, it is required of them to conduct an effective environmental social impact assessment. My Lord, to discuss this, I'll submit my argument in two limbs. First, on the right process of conducting an environmental social impact assessment, and second, I will show that public participation was insufficient. The process for conducting an environmental social impact assessment is outlined in the Environmental Impact Assessment Regulation Audit under Section 11 to Section 17, which states as follows: preparation for terms of reference, approval of experts, registration of environmental experts, preparation of the area, public participation, submission of the report to the authority, and then the authority shall after keen examination, make a decision within 3 months. My Lord, my ladies, although it is true that some sort of environmental social impact was conducted, that environmental social impact was very effective. My Lord, the National Environmental Management Authority went ahead to give a green light to Tamul Limited to start their project before subjecting the report to strategic environmental scrutinization.
Council. But according to paragraph 18 of the statement of fact, don't you think we should consider the government's effort to try and carry out public participation despite the fact that they faced various challenges?
My Lord,
And also to add to that, is the test of public participation a quantitative test or a qualitative test?
much obliged, my Lord. The test for public participation is both qualitative and quantitative, but more of quantitative, because we are talking of policies that are going to affect lives of people, my Lord. Pardon, my Lord.
Oh, I was asking, don't you think we should consider the government's effort to try and carry out public participation, considering the fact that we see that the government encountered various hurdles when trying to conduct the public participation?
Much obliged, my Lord. Issues of public participation are not issues of personal consultation. They are issues of constitutional and statutory provisions. Therefore, if you do not meet the threshold for public participation, that means that the public participation was duly conducted.
Council, it begs the question, what is the constitutional and statutory provisions on public participation, specifically on the threshold that is stated?
My Lord, very much obliged. Under Article 10 of the Constitution of the Republic of Malindi, it states the right to public participation, although it does not state the threshold for public participation. But it is the constitutional assertion that when making decisions that are going to affect the lives of people, whether regulatory, whether statutory, or whether constitutional, they should acquire the views, and it is also a requirement under the MCA, under the Regulation Act 2003, Section 17, subsection 2, which requires mandatory public participation. Seeing that my time is further spent, I would like to ask for 2 discussion meetings to sum up argument.
Okay, we grant you that, but still not responded to the question of the threshold. Probably a case in court or a statute. On the threshold, yes, it's a principle, it's a constitutional law principle, it's part of the national values, but then what threshold should the respondent have done to satisfy you as the petitioners that they have conducted public participation?
Much obliged, my Lord. It is the requirement of the Paris Agreement, Article 18, which requires that public participation must be conducted, and in conducting this public participation, to ensure that people are contented with the public participation as stipulated under Article 28 of the Constitution of Malindi, there should be views of people more than 50% of the people affected. My Lord, it was also a requirement in the compromise that Professor Bakari still needed to interact with more than half of the people who are supposed to be affected by the project.
So sorry to take you back. Which legal provision have you stated that public participation must consist of more than 50% of the population? Which is the legal provision of that?
In the case of Mugo and 14 others versus Matiani, in the High Court in Chuka, the court held that public participation is the centerpiece for decision making in activities that affect the lives of the people. It went further to give the test for public participation, which inquires inclusivity and diversity, which requires sufficient notice to the people, and it also requires engagement to be more than half of the people who are going to be affected by the actions, by the activities. Therefore, it being a requirement to state organization and even non-state organizations, it was a requirement for the government to conduct a proper environmental social impact assessment, which should have had the views of more than 50% of the affected population.
So, Council, in your remaining time, could you kindly tell the court on some of the measures you would have recommended the government to take to ensure that more people participated in public participation?
Much obliged, my Lord. On the measures that the government should have taken, they should have tried to mitigate the risk associated with the project. It being considered as a soft ground, they should have undergone for another alternative to this project.
What alternative, Council? Do you have any?
My Lord, my lady, there are other alternatives to sources of income, because before the commencement of the project, the state was well run.
You can wrap up your submission because of time.
In conclusion, it is our prayer that this court finds that the environmental social impact assessment conducted was duly flawed and that it violated the constitutional right to public participation. Although we are not saying that everyone had to issue their views, the public participation had to show intentional and inclusivity. Therefore, by them failing to show or to inform the community on crucial information associated with the project, they failed and they did the public participation as a mere formality.
So, Council, in one sentence, so which relief are you seeking according to Article 23 of the Constitution?
Much obliged, my Lord. According to Article 23 of the Constitution, we seek the relief of a declaration of rights, my Lord. In conclusion, it is our prayers that this honorable court finds that it has the jurisdiction to hear this case, that the parties have local standard, and that the case is admissible. It is also our prayer that they find that Tranur Limited is eligible for gas emissions. It is our prayer that this court finds that the Republic of Malindi is liable under international law, and it is our submission that this court finds that the environmental social impact assessment process was duly flawed and violated rights to public participation. Therefore, if this bench seeks no further clarification, I'd like to cede the floor back to the bench.
Council for the respondents. And kindly, the respondents should try to restrict their submissions to respond to what the petitioners have said. Strictly respond to the petitioner's submissions.
Greetings, honorable members of the bench. My name is Austin Nangamurili, and I am the lead counsel appearing on behalf of the respondents herein. With me, I have my co-counsel, Samba Deborah, and together we appear for the Attorney General of the Republic of Malini, National Environmental Management Authority, and Internal Moot Limited. We will use the time graciously accorded to us by this court as follows to respond to the arguments posited by the petitioners. I will use the first 10 minutes to aver on the merits of the first and the second issue, whereas my co-counsel will use the remaining 10 minutes to aver on the merits of the issue C and issue D. Whereafter, she will conclude by stating our prayers. Unless there are no further directions, I wish to proceed.
Proceed.
Honorable members of the bench, on our first issue, it is our assertion that this court lacks the requisite jurisdiction, that the matters herein are inadmissible, and that the parties herein have local standard. I will address this issue threefold: on jurisdiction, on admissibility, and lastly on local standard. I will begin with local standard. We aver that the parties herein have local standard to appear before this court, pursuant to Article 22, 2, C and D, which provides that the parties, any party who claims that a right or a fundamental freedom has been breached can be able to pursue the same in accordance with public interest. It is therefore our assertion that the petitioners herein are appearing on behalf of the citizens, hence they have local standards since they are appearing in accordance with public interest. On our second issue, it is our submission that this court, that the matters before this court are inadmissible. It is our submission that the matters herein are inadmissible due to the lack of exhaustion of local remedies. According to Article 159 2C, it provides for principles that need to be looked into when seeking access to justice by the courts. It provides for alternative forums of dispute resolution, and we aver that the petitioners herein fail to exhaust the local remedies. We rely on Mohammed Ali Mbadi versus AG and 11 others in 2018 before the High Court. In this case, it was stated that for the exhaustion doctrine to apply, it must be effective, must be accessible, it must be timely, and it must be affordable. So in essence, this means that the avenue to seek justice must address the issues in totality. It is our submission that according to paragraph 14 of the compromise, the Republic of Malindi sought the help of the World Bank to fund the Kasiri Cement Project Fund. It is our submission that the root cause of the Kasiri Cement Project is the World Bank. Hence, they are tied. The World Bank established an independent assessment mechanism with which they stated that this independent assessment mechanism, through the peoples affected by the project, according to the independent assessment mechanism, peoples affected by the project was supposed to take into account the disputes, any dispute that will occur when implementing the Kasiri Cement Fund project.
So, Council, let us hit the nail on the head and let us contest jurisdiction per issue Now you're telling us they did not exhaust local remedies. Now take us to issue 2. Tell us which tribunal could have addressed the second issue. Take us to the third issue. Tell us which remedy could have addressed that issue. Take us to the fourth issue. Tell us which remedy could have addressed that issue. Now you have taken us to the independent body set up by World Bank. Which issue could it have addressed? Is it all the issues?
Much obliged, my lord, and I do not your concern. However, it is the respondent's affirmation that the independent assessment mechanism was to handle all the matters. It was supposed to handle the matters involving the greenhouse gas emissions as well as the environmental disasters in according to the issue 2. It was supposed to handle the matters including the transboundary environmental harm to Samira, as well it's supposed to handle the environmental and social impact assessment according to issue 4. We submit that the independent assessment mechanism by the World Bank is sufficient to handle all the matters herein. Proceeding on jurisdiction, my lords.
Council, sorry to take you back. Is the body you just mentioned, does it have the power to declare government policies unconstitutional?
Much obliged, my lord, and I do not your concern. It is our government that in as much as the matter herein involves a constitutional right, which involves the public participation, the matter is under the root cause of the Kasiri Cement Fund project. And according to the compromise, we see that the independent assessment mechanism is supposed to take into fact all these issues.
Council, 2 questions.
Yes.
1, can those local remedies deal with the issues of human rights? And 2, is the notion of exhaustion of local remedies absolute? And if it's not absolute, what or in what ways can we see the exceptions? Thank you.
Much obliged, my lord. And in response to your second question, we aver that the doctrine of exhaustion of legal remedies is indeed not absolute, and we rely on the case of Republic versus IEBC and 6 others in the High Court, where it was stated that an exception to the exhaustion doctrine is that where there is a constitutional value at stake. And I do note that I do acknowledge the concern of another honorable member of the bench, and it is our government that in as much as the matter here involves public participation of the environmental and social impact assessment, it is our government that this matter was sufficient. The independent and assessment mechanism was sufficient under the World Bank to handle this matter. In response to your second question.
Sorry to take you back. Are those provisions, are those remedies by the World Bank provided in any statutory provisions or any law?
Much obliged, my lord. And I do not your concern. According to the case of Geoffrey Kabiru versus Samuel Henry in the Court of Appeal in 2015, it was held that the jurisdiction of this court cannot be invoked, where an alternative dispute forum suffices. Hence, it is our submission that the independent and assessment mechanism, according to the paragraph of the compromise, we state that it was sufficient to handle all the matters herein. On jurisdiction, my honorable members of the bench, we further rely on the Geoffrey Kabiru case of 2015 before the Court of Appeal, whose decision is binding before this court. Where it was stated that where an alternative dispute forum was not sought, where it was not explored, then this court cannot have jurisdiction to handle the matter herein. Honorable members of the bench, in the rare occasion that this court finds that it does indeed have jurisdiction and the matters herein are admissible, I will present on the subsequent issues since a case has been meted before us and we reserve the right to reply. On to my second issue, Your Excellencies. My lords, sorry. It is our submission that Talmud Limited is not liable for the environmental disasters as well as greenhouse gas emissions, which led to floods, which led to health impacts, as well as landslides. We will discuss this in the following limbs of argument. On our first limb of argument, it is our submission that Talmud Limited cannot be held liable since this was an act of God. We rely on the definition of an act of God pursuant to the Black's Law Dictionary, where it was stated that an act of God is an overwhelming and unpreventable event, and which is caused exclusively by forces of nature, such as earthquakes and floods.
Counsel,
Yes, my lord.
you said that this was an act of God since it was unforeseeable and could not be prevented.
Yes.
However, the petitioner submitted that you, as the government, ignored the results of the environmental impact assessment test and further submitted that if you adhere to this report, then this could have all been avoided.
My lord, I did not get your question. Kindly rephrase it.
Or the petitioners have submitted that this could have been prevented if you, as the government, had simply adhered to the results of the social impact assessment test.
Much obliged, my lord. It is our submission that these events could not have been prevented. We rely on the case of Kenya Wildlife Services versus the Rift Valley Agricultural Contractors before the Supreme Court in 2015. In this case, which is binding before this court, it was held that the criteria is not whether or not the event would reasonably be foreseeable, but whether human foresight would recognize the possibility of such an event. It is our submission that subject to the environmental and social impact assessment, this was not foreseeable. In the case of Kenya Wildlife before the Supreme Court in 2015, it was further held that when you are looking at the acts of God, you are looking at what can be prevented or avoided by due care or foresight. It is our submission that the greenhouse gas emissions as well as the environmental disasters would not have been attributed to Talmud since they did not satisfy this criteria. We rely on the test in that case where the test includes a four-part test. In this case, we have causation, lack of foreseeability, nature must be the sole cause and not human intervention. And lastly, effects must have not been preventable by reasonable due care or foresight by the defendants.
Counsel, because of time, the bench will agree with you that the floods and the landslide were an act of God. But now let us go to the health impact of the community. Talk us through the lime poisoning and tell us whether the same is an act of God. The lime poisoning from River Birenga, is that still going to be an act of God?
This is also keeping in mind that the state under Article 43 of the Maldives Constitution is mandated to the highest attainable to the realization of the to the realization of the highest attainable standard of health and sanitation.
Much obliged, honorable members. In response to the health impacts, it is our submission that the same had already been existing. This was already in existence and cannot be attributed to Talmud Limited. We rely on the case of Tyran Industries Limited versus the National Environmental Management Authority in 2014 before the Environment and Land Court. In this case, the issue was whether, in assessing causation, the issue was on causation. In assessing causation, the acts of when you are attributing liability, it has to be akin to causation. And in this fact, we can see that it is not You cannot attribute possession to Talmud Limited. This is because the limestones deposits were already in existence. Hence, it is our submission that Talmud Limited, due to lack of possession, cannot be held liable for the health impacts due to limestone deposits. Honorable members of the bench, it is our submission that the state acted in good faith. According to paragraph 11, we can see that there was economic growth. We can see that there was...
Just a second. I'll still lead you back to that. I'll lead you to NEMA guidelines. And in the NEMA guidelines, we see that one of the guidelines is there should be an action plan for the prevention and management of foreseeable accident during the project cycle. That's in formulation of the report. My question is, has the government provided that in terms of these environmental, because we see the risks, do we have the action plan to manage those stated risks? Even though probably the unprecedented event for me, told you we can say that those are the acts of God. The ones that were mentioned, the ones like the soft ground, has the government managed? Because we see a landslide killing many people. What have we done as the government or the respondents in that?
Much obliged, honorable member of the bench. Kindly allow me to direct you to paragraph 8 of the compromise, where we can see that Malindi has implemented climate change actions which include afforestation, reforestation, and this is through tree planting programs, all to meet climate resilient goals. It is our submission in conclusion that the Talmud Limited, as well as the Republic of Malindi, acted in good faith. It helped in putting forward mitigation measures which can be able to be seen throughout the paragraphs in the compromise. Yes.
That does not respond to my question. My question is directly on the project report. We see the environmental social impact assessment test or report providing on specific risks, right? Do we see the government acting on these risks, or exactly after these risks are mentioned, we see in less than 3 weeks, the NEMA giving Kasiri the chance to continue their project?
Much obliged, honorable member of the bench. We will rely on paragraph 4 of the compromise, where we see that the Republic of Malindi is a developing state. It is a developing country. It is relying on rain-fed agriculture. It is relying on tourism as well as natural resources. It is our submission that due to the erratic climate change patterns, the risks, even given the risks in the environmental and social impact assessment report, the risks could not have been mitigated, since this was an act of God. Further, relying to cement my argument, relying on the case of Kenya Wildlife before the Supreme Court, it was stated that the criteria is not whether the event could reasonably be anticipated. We can see that it was reasonably anticipated in the environmental and social impact assessment report, but whether human foresight could reasonably recognize the possibility of such an event. Hence, it is our submission that since this was an act of God, Talmud Limited cannot be held liable for greenhouse gas emissions as well as environmental disasters. With that, I cede the floor to my co-counsel.
Greetings, honorable members of the bench. May it please the court, as earlier introduced, Samba Deborah is my name, appearing on behalf of the respondents, and I will be taking 10 minutes of the honorable court's time to address the last two issues, where, on issue C, it is our submission that the Republic of Malindi does not bear responsibility for the environmental transboundary harm caused to the people of Samira under international law. And to argue out our case, we shall rely on Article 2 of the draft Articles of Responsibility of States for Internationally Wrongful Acts. And this act states that for a state to be held responsible for an activity, then the following has to be shown. First, the act or omission has to be attributable to the state, and secondly, the act or omission has to constitute a breach of the obligation of the state under international law. And I will start on the first line of argument on the issue of attributability. In any case that the petitioners are able to prove that Talmud industry is liable, then the actions of Talmud industry cannot be attributed to the Republic of Malini. We shall rely on Article 8 of the draft Articles of Responsibility of States for Internationally Wrongful Acts.
Oh, sorry, the petitioner had submitted that you as the government are vicariously liable for the actions of Talmud Limited. So would you kindly explain on what grounds you say that the government is not liable, is not attributable to the actions taken by Talmud Limited?
Yeah, we submit that the government shall not be, the acts of Talmud industry shall not be attributed to the government since, as I was stating, according to Article 8 of the draft Articles of Responsibility of States for Internationally Wrongful Act, for the conduct of a person or a group of persons to be attributed to a state, then it has to be shown that this state directed, controlled, or influenced the conduct of the person or the group of persons. And therefore, we shall rely on the case of Nicaragua versus USA of 1986, which was decided in the International Court of Justice. And in this case, they established two control tests, which are to show attribution. We have the effective control test and the strict control. We have the effective control test and the strict control test. For the strict control test, you have to show that the state had control over the state, and that over the person or the group of persons, and that the group of persons were not independent and had no autonomy. For the effective control test, you have to show that the person or group of persons were partially dependent on the state for you to be able to prove the effective control test. And it is our submission that Talmud industry was independent and in no way under the control of the state of Malini, and therefore their acts cannot be attributed to the state of Malini.
Also, by reading of the facts, I understand that you contracted Talmud Limited. So you don't have control. I did not get the exact test you are trying on. Are you using the effective control or the strict control? And is the strict control the same as the overall control? And again now, if you do not have control of this company, yet you are under a contract, why didn't you terminate that contract and end their services? Because you are the ones who brought that company to work in the state.
Okay, thank you for your question, much obliged, and it is our submission that the government of the Republic of Malini did not control the Talmud industry in any way under the strict control test or the effective control test. It was in no way, the Talmud industry was in no way under the control of the state. And it is our submission that for the fact that we had the independent accountability mechanisms for the people to be able to bring their issues, then the state had measures in place to be able to control the whole situation. And therefore, I will proceed to my second limb of argument, where to be able to prove responsibility of a state, you have to show that it constituted a breach of the obligations of a state. And to show this, it is our submission that the harm that was suffered by the people of Samira was unforeseeable. move with me, honorable members of the court, to paragraph 1 of the compromise. And in paragraph 1 of the compromise, among the states that were boundary, or rather neighboring the Republic of Malindi, Samira does not appear as one of the states neighboring Malindi. And therefore, it was not foreseeable that any harm that occurred in the Republic of Malindi will be able to cause harm to the people of Samira. Secondly, move to me to paragraph 25 of the compromise. In paragraph 25 of the compromise, not only is it stated that the people of Mirenga Valley received unprecedented rainfall, but this rainfall was also heavy, overwhelming the natural defenses of the Mirenga Valley area. Making matters worse,
Council, is it not foreseen that the river, the Mirenga water flows to the ocean, which is also shared by that state? So even if it's not foreseeable that the other transboundary harm can happen, that at least for the waterways, it's very clear the water flows to where you share a specific resource.
Much obliged, my Lord. And to answer your question, allow me to continue with my submission. As I have stated, they received unprecedented rainfall, which was heavy and overwhelmed the natural defenses of the Mirenga Valley area. To make matters worse, the unique topography of the area contributed to the path and the magnitude of the flood waters. And that is why the natural contours led the flood waters to the valley area, therefore causing a significant rise in River Mirenga, which therefore flowed into the Azua Ocean. And it is our submission that this sequence of events were unforeseeable as they were contributed to by the nature and the natural landscape, or rather the way the Mirenga Valley is built. And therefore, as this water flooded into the Mirenga Valley, it emptied itself into the Azua Ocean, therefore causing the harm that was suffered by the people of Samira.
Also, I'll start with some yes or no question. Do you agree that we have transboundary harm to the state of Samira?
We agree that we have transboundary.
And you agree that the transboundary harm is coming from your region as a state?
Yeah.
What have you done as a state? Because the obligations in the treaties and conventions are directly to the state and not to individual companies. What has the state? Because the first question that was asked by my co-judge was clearly that you are the one who signed this treaty with this company, right? And you allow this company to be part of the territorial sovereignty. What have you done in terms of both mitigating or even remedying these aspects of transboundary harm that you agree has happened?
My Lord, thank you for your question. And it is our submission that as this harm was unforeseeable, there is no way that the state would have taken any preventative measures to mitigate any harm from our state to other states.
Council, there are measures before harm and measures after harm. What measure of due diligence after harm have you done?
For fear of misleading the court, I'd like to submit that the compromise is silent on that.
So, does that mean you have taken no measures with regards to mitigation after harm has been done?
Not any that I know.
Council, we are aware that you are the representative or the agent of the respondent state before this court, right? And we all agree that you have transboundary harm that has moved from your country to another country, right? Don't you think that your state or you as the respondents have an obligation of ensuring that this harm is remedied?
Thank you, my Lord, for the question. And it is our submission, or rather it is our averment, that the fact that we did not have control over the sequence of events, or rather the activities that happened, we do not have the obligation to remedy this situation, as it was an unforeseeable event, and therefore we cannot be held liable under the draft articles of responsibility of states, Article 23, which precludes states from responsibility for acts that are caused by force majeure. If it please the courts, I'd like to move on to my last issue, where it is our submission that the effort we put in conducting the public participation demonstrated reasonable efforts despite the challenges that we faced. Honorable members of the bench, move with me to paragraph 19 of the compromise. According to paragraph 19 of the compromise, it is stated that we faced various challenges in conducting the public participation process. And these challenges include the rugged topography of the area and the widely separated communities created logistical issues. Secondly, we had time challenges which led us, or rather interrupted our interaction with the members of the community. And thirdly, we had limited budgetary and staff resources, forcing a compromise between fiscal responsibility and physical outreach. Now, it is our submission that in conducting this process, we attained what can be seen as a reasonable effort to conduct a public participation process. We shall rely on the case of Mui Call Blessing Local Community and 15 others versus Permanent Secretary of the Ministry of Energy of 2015, which was heard by the High Court. In this case, they stated a South African case that goes by the name Nuclic South Africa Limited versus Ministry of Health. And in this case, it was stated that a reasonable process, in this case, it was stated that a public participation process is capable of infinite variation, and what amounts to a reasonable standard is dependent on the circumstances of each case, and is therefore a bar. And we shall also rely in the case of Caps Parking Limited and another versus County Government of Nairobi and another, which was heard in 2021 in the High Court, and it stated that the adequacy, mode, and extent of such participation largely depends on what is reasonable in the circumstance of each case, my lords and my lady. Having stated our circumstances and the challenges that we faced, surely we represented, or rather we showed reasonable effort in conducting the public participation process. And secondly, we shall address the measures that we use, or rather the mechanisms that we use in conducting the public participation process. Yes, my lady.
You say you faced budgetary challenges, right? However, according to the facts, there were some funds that you actually received. That is, that's paragraph 14. 30,220,485 to fund the project. So how can you say that you didn't have the funds to fund the public participation?
My lady, I would like you to take into consideration that first, this is a third world country. And secondly, the public participation process was being conducted by Bakari's team, which was given the authority by Internal Industry. According to section 58, part 2 of the EIA, that is the Environmental Impact Assessment, it is stated that any proponent of a project shall undertake or cost to be undertaken at his own expense. And therefore, with regard to the fact that this is a third world country and that the Talmud industry was conducting this at their own expense, then we surely could, the possibilities of facing a budgetary, or rather having a limited budget are high. And therefore, it is our submission that that is the reason why we had these budgetary limits.
So, Council, how does your state balance fiscal responsibility to comprehensive outreach in matters of public participation?
Thank you, my lady, for that question. And it is our submission that could you repeat?
How does the state or the government balance fiscal responsibility to comprehensive outreach in public participation?
As you try to answer that, I have two questions. And I appreciate the council for the respondent line of thought in citing the Mui case, because it set out the five elements minimum requirements for public participation. And I'm interested in the two of them. One, it says that it is not a requirement that everybody or everyone's views are taken into account, but it does not say that you should intentionally eliminate some group or some population. From the facts, you eliminated intentionally excluded 53%. So what is your excuse on that? On the second element, it says that you should take into account logical constraints. Logical. Now, the constraints you are giving us is one, the topography of the valley, and two, the finances. On the finances, you have been asked to have money. So you are prioritizing to use money for the project and not for public participation. And again, the logical constraint on topography, you have to, according to Regulation 17, of the Environment Impact Assessment and Audit Regulations of 2003, you are supposed to do announcements and notices. I believe that is not affected by the topography. So how are the constraints that you wrote in the study logical logical constraints under the requirement in the Moot Court case?
Thank you, my lord and my lady, for your beautiful questions. And my lady, in answering your question, on the balance of fiscal responsibility and physical outreach, I'd like to rely on the case of Mui Basin, where Mui Basin local community and 15 others versus Permanent Secretary of Energy and 17 others of 2015, which was heard in the High Court, where in setting the standards, or rather whatever is needed to be reached in order to conduct a public participation process, as my lord has stated, it was stated that not everyone has to give their views when conducting a public participation process. And therefore, in balancing the fiscal responsibility and public outreach, we carried out our responsibility, but we were unable to reach out to these people due to the constraints that we faced. And therefore, we compromised the physical outreach for the fiscal responsibility. And secondly, my lord, on your question,
the logicality of your constraints. Explain the logicality of the constraints. The topography and the finances. How logical are those constraints according to the requirement of the Moot Court case?
My lord, on your question, you asked that in conducting public participation process, you are supposed to do activities like making public announcements, and it is my avowment that such mechanisms were used, because according to paragraph 19 of the compromise, it is stated that we took a multi-channel communication approach using the local radio broadcasts, public announcement, and collaboration with community elders. We had these public announcements that were made to the community, and the mechanisms that we chose, we hereby submit that were fit according to our circumstances, because these mechanisms were aimed at reaching a wide population of the members.
So now what about the qualitative and quantitative basis of your public participation? You did not take into account the risks that you saw. So that question is the quality of the public participation. So why didn't you take into essence the outcome of the study?
On why we did not take into account the outcome of the study. According to paragraph 14 of the compromise, it was stated that this environmental impact assessment was supposed to be studied and was supposed to be taken, and any complaints or any other thing, or rather the results of the public participation process was supposed to be given to the World Bank, or rather was supposed to be given back. And therefore, it is our submission that these views that we took were properly worked on. And therefore, on my last argument, on the issue of the mechanisms used, as I have stated the mechanisms that we used before the Honorable Court, I will rely on the case of Independent Electoral and Boundaries Commission versus National Super Alliance Kenya and 6 others of 2017, which was heard in the Court of Appeal, where it was stated that the first respondent had the discretion to choose mechanisms they deemed fit in their circumstances. And therefore, with this discretion that was given under the Court of Appeal, we submit that we chose mechanisms that were fit in conducting the public participation process in our circumstances, and therefore we demonstrated good faith in conducting the process, and therefore showed reasonable efforts. And with that, and in light of our arguments, I would like to proceed to our prayers, where it is our prayer that the court declares the following. First,
we still have time to do this. Council will infer your prayers, but we will ask a question on relief. So, which specific relief are you seeking according to Section 23? According to Article 23, rather, of the Constitution, which relief are you seeking as the respondent?
We are seeking orders by this court. First, that to be able to declare that it does not have jurisdiction to handle the case brought before this court, and that the parties do not have a locus standi to appear before the court, and therefore that this case is not admissible. And secondly, an order that Talmud industry is not liable for its contribution to greenhouse gas emissions and environmental disasters, particularly in escalating the climate vulnerability of the region, particularly with regard to the floods, landslides, and health impacts of the community. And thirdly, that the Republic of Malini does not bear responsibility under international law for the transboundary environmental harm to Samira. And lastly, that the environmental and social impact assessment process were done in good faith and it demonstrated reasonable efforts in carrying out the public participation. With no, and I would therefore like to cede the floor back to the bench for further direction.
So we are behind schedule. I believe we are having things. We can have comments from the judges. We can start from. You have rebuttals. 2 minutes. 2 minutes. We are behind schedule.
Greetings, honorable members of the bench. We intend to use the 2 minutes to submit our rebuttal as follows. The respondent has argued that they conducted sufficient public participation due to the constraints that were there. But it is our submission that Inokia Untata was at the Kenya Revenue Authority in 2022 in the High Court in Nairobi. The court held that the presence of COVID-19 could not substantiate or give the Kenya Revenue Authority the mandate to impose tax laws, although they were required to conduct a proper public participation. And it is also the requirements of the Environmental Management Coordination Act under Section 21, subsection 3, that provides participation as public participation is mandatory, and in this public participation, they should inform the people on the anticipated risk and the proposed mitigation measures that they are going to take in light of the risk. It is also the respondent's submission that the World Bank was the root cause of the project of Kasiri Cement. That is very wrong. My Lord, we are submitting that in paragraph 10, it was the government licensed geologist that conducted the survey, And in paragraph 14, the government went ahead to seek help from the World Bank to fund the project in Kasiri. My Lord, it is also a submission that it is the averment of the respondent that limestone poisonings already existed before. Although in paragraph 23, the residents complained that once colorless water was looking milky. Hence, it is the activities of the government that led to the exposure of the limestone to the environment. My Lord, it is our submission that the respondent's submission stated that Talmud acted in good faith, although it is evident under paragraph 18 that they failed to disclosure the risk identified in environmental social impact report, and that violated also the Environmental Management Coordination Act section 21(3). Therefore, I'd like to see the floor to the bench.
Council, the submissions have been noted. Let's have comments.
Sorry, before we have comments, we've already secured the media team so that we can take photos of the participants. So I think we can have comments and the results after, so that you can speak. Time can move on. I know you guys want to really know also whether you've proceeded, and I know as they take photos, they can proceed to tally, and then we can know the results after. So I kidogo tu kuchange, tuchukue picha. Yes, tafadhali. Yes, mnaweza kuja na soda hadi, please. Please. Yes. No, you want to do it here. So you can tally, please tally in the meantime, so that results will be announced after.
All your friends wakuje kuna round. Wewe class yako mbona unasupport ya team? Hii round ni class yako. Wewe cheki hapo kwa hapo class yako. Oh, mbili. Surely class ni almost 80 students. Kuna comments to the judges. Nini watu wanapata zero. Neka zero sikana. Nashangaa. Hapa anza nianze kuweka hizi marks. Tunaweka za dimina hapa. Kwa sisi usipe. Shadow subjects. Ya dimina niweke. Shadow kujaji leo subjects unafanya. Sasa hiyo ni presentation. Anything you say bila shomaya. Niweke dimina zero. Unaniita shomaya. This person, they are posting him on person's day.
Hadi anabaki. Semi-finals tunakuja hivyo. Wewe hata usijue kumwambia. Mwambie akoje.
Nini hiyo nini? Nimevaa blazer. Sio fake bashati ya mimi.
Hajapata.
I don't have to wear clothes. Yeah.
Section?
Which section?
I have to ask a question. How do I shoot? For the sake, please shoot. We already done shoot. For the sake of the scores. Now, I want to ask, are we announcing the results right now? No, we are announcing the results.
Unajua kwa ABC
Ile tunda shambani. Tunda shambani. Wewe mtu anasema nini?
For the teams that have already voted, there are more photos if you want. You will follow the video team. Please let us hurry so that the next council starts at 8. Please let us hurry. Yes, yes. Take your soda, take everything that you need. Yes. Yes, please let us hurry.
The judges are requesting to accuse themselves if you don't have business.
Be provided immediately after we start the session. Yes. It shall be provided immediately after the session. Thank you.
That's a good order.
Yes, it is in order. Let us please.
I'm very happy.
You didn't sweat to say it. Only the first round.
Wait. Yes.
Shida watu. Ana jinenye fail. So ukiwashinda atakuwa jina yake ni fail. Shida atakuwa umefail. Kirusi itakuwa umefail. Zaira.
It's not a local name.
The latest we should begin is 551, 530. The latest.
Conflict of interest.
The media were saying that they want to conclude the picture session side because wanasema wataenda. So twende tukachukulia picha so that we can come. Apologies for the delay. I really want photos of you guys for marketing. Yes.
I'm liable for everything here. You do not want to take photos? So I am liable even for the Betty's and everything. Yeah, that's why everything has been written down.
Yeah, but
but I get up Committee. Hi. Toilet control picture. We have to close the moot court because there are a lot of balconies here. So please, if you're going to leave the key of the moot court cover.
Soda bana. Senyewe. Nani ameleta? Senyewe. Kulia senior audience. Next one nazalisha. Next time.
Any applicants? Yes. Anything.
Okay, cool. What's up, man?
Chapter to switch.
And okay. Mayor, with that attire.
We got what? I have an adult in my own place. There you go, the capacity. You want to sit on that side? You can sit on any side. On any side, huh? Whose key is this? Why? Okay. But last time you also last so you can sit in. I don't know. Have you ever seen a car?
Whichever. What happened? And see it, man.
Yeah, let me enter the live. Let's start a new one. Everything is good. Everything was good. Correct in the video. Microphones, where are they? So we took another. No. Kuna moja hapa. The second one. The second microphone. Huh? Let me end this round. Let's start another one. Let's